But there is something else which gives concern to a wide cross-section of the general public, which has sadly not been addressed in this bill. It is the way freedom of speech has been undermined by what we might call over-enthusiastic policing, something often generated by the pressures of political correctness, which cause officers to overreact to situations when no harm is being caused. To voice one's opinion without fear of punishment or censorship is a fundamental human right. Without this, political action and resistance to injustice and oppression is impossible. It is a precious right, and we must not allow it to be undermined. There are several pieces of legislation that have been suggested for amendment to improve free speech. But I want to focus, as my Right Honourable friend, the member for Gainsborough, did earlier, on Section 5 of the Public Order Act 1986. Section 5 outlaws threatening, abusive or insulting words if they are likely to cause distress. And Section 5, as we have already heard in this debate this evening, been at the heart of several high-profile cases in recent years. Liberty wisely took up the cause of a 16-year-old protester who was given a court summons by police for holding a placard outside a Scientology centre saying, "Scientology is not a religion, it is a dangerous cult." The boy claims police told him he could not use the word cult. City of London police gave him the court summons and confiscated the sign when he refused to take it down. They referred to the Crown Prosecution Service an allegation that the sign was abusive or insulting. When Liberty took up the case, there was widespread criticism and the CPS dropped the case. Now, as my Right Honourable friend mentioned earlier, the defence of this, of the existing law, has been that guidance can be given to the police. But it didn't work, and it hasn't worked in a whole number of cases. Dale McAlpine, a Christian street preacher, was arrested in Cumbria for answering a question from a police community support officer about his views on sexual ethics. He said the Bible described homosexual conduct as a sin. He was arrested and detained by police for nearly 8 hours. Even the president of the National Secular Society said the police response was ridiculous and over the top. I find myself in agreement with the renowned campaigner Peter Tatchell, who said, "If offending others is accepted as a basis for prosecution, most of the population of the UK would end up in court." He is quite right. In a similar case, another street preacher, Anthony Rollins, was arrested, handcuffed, and kept in a police cell for 4 hours after a passerby was offended by him reciting a biblical list of those who would not inherit the kingdom of God. Now, I'm a Christian myself, and I might not agree with that method of evangelism personally, but the idea of someone being arrested for reading from the Bible in public is a very worrying thought. And once again, the ACPO guidance to police officers didn't work. Mr. Rollins got help from a Christian campaign group, the charges were dropped, and they helped him bring a legal action against the police. The court decided that Rollins' rights to freedom of religion and freedom of speech had been breached. They had been wrongfully arrested, had suffered assault and battery by being handcuffed, and was unlawfully detained. But the police are appealing against that ruling. Despite everything, West Midlands Police think that Section 5 allows them to arrest street preachers for reciting the Bible. Clearly, the police are having difficulty applying this law and the guidance that the Home Office says should deal with the problem. And as my Right Honourable friend mentioned earlier, some of these cases are just plain ridiculous, and it's astonishing that the police are wasting time with them. In 2006, demonstrators in Worcester protested against seal culling, using toy seals coloured with red food dye. A harmless way of making a point. But they were threatened with arrest and seizure of property under Section 5. Police told them that the toys were deemed distressing by two members of the public and ordered them to move on. Ridiculous. Now let me say, as the grandson of a police officer, I feel sorry for police officers. They have to make extremely tough decisions day in, day out, often under the most extreme pressure. They get criticism from all sides. They're too rough, too soft, insensitive or oversensitive. They just can't win. And frankly, the media rarely gives them a break. I don't want to run down the police. What I want to focus on is what we as legislators in this place can do to avoid putting them in a situation where they have to decide whether a complaint from someone who feels insulted should result in an arrest.
I'm going to give way.
Certainly.
I'm going to my defendant. He's making an important and very strong case. Is he aware that before he quite properly and welcomely came to this House, the debates around public order have occupied this House, particularly when dealing with other cases, for example, homophobic hatred, and where many examples that were raised when concerns were expressed about the application in that case lent themselves back to this issue of Section 5 and their wide interpretation and the need for us to take a proper, thorough look, and this is an important opportunity to do so.
I'm extremely grateful for my honourable friend's intervention. He makes a powerful point and really underscores the fact that this legislation, this Freedom Bill before us today, must take account of this anomaly, and it's unfortunate that it doesn't. We have to ask ourselves, should the law really criminalise insulting words? Surely insult is in the eye of the beholder. How can the police be expected to regulate that? Abusive behaviour is clear-cut. We all know it when we see it, and it is right that the law addresses it. And threatening behaviour is absolutely unacceptable, and we need laws to tackle it. But insult? What would debate be like in this chamber if an honourable member could be silenced, Madam Deputy Speaker, by an allegation from another honourable member that he felt insulted by what someone else had to say? In July of last year, my right honourable friend, the Deputy Prime Minister, told us that this bill would protect hard-won liberties and repeal unnecessary laws. The government has made a good start, but it should seize the opportunity presented by the bill to bolster freedom of expression by removing the word insulting from Section 5 of the 1986 Act. Freedom from wheel clampers, but no freedom of speech. It doesn't make sense.